Good afternoon, everyone. Welcome to another episode of Spilling Tea. I'm your host, Tiffany Daniels, and it is my pleasure to introduce you all to one of the next series we are going to be getting into, which is going to be in regards to HIPAA. Before we start getting into it, brief disclaimers, trigger warnings, and I'm going to go into exactly why we are doing this series and how it relates to what we've been doing and covering lately. So, folks, regards to our new series in regards to HIPAA and what our protections are, as well as how to fill out a HIPAA complaint. Considering who is our head of public health, I feel like this is particularly pertinent information to have on hand, particularly since this individual also had the concept of an autism registry. So, everything that we're going to cover in the HIPAA series, you're going to find right there in the description box, including this starting page that we are beginning today. And before anybody else wants to come into the comment section and use the lame joke of Trump derangement syndrome, can I please ask you, if you're going to be insulting, can you at least be somewhat entertaining and just show some spark of creativity? You know? Act like you at least have one operating brain cell. Sorry, folks, but God. It's like when fake celebrities follow me on social media. I always prefer the dude who's always trying to recruit me for the Illuminati because at least it's something original. But anyways, you'll find that all in the description box. Trigger warnings, as you guys know, this channel's marked not for kids for a reason. I do use profanity, and some of the topics that we cover are pretty dark. So if you got a child that's 16 and younger and they are watching this, parental supervision is very much advised. Now, political slash pseudoscience trigger warning. If you are gung ho, MAGA, MAHA, or both, or you are completely on the opposite end to the point of being delusional, I am neither of those things. Which means at some point, at least in one of these series we are doing now, I am probably going to say something that's probably going to offend you. If you're gonna do the insults in the comment sections, guys, please at least make it original. Find new material. This TDS crap is old, lame, and just lacks all spark of creativity. Give it a real try. You know? Really go for it. Anyways, usually, guys, I will just simply remove the comment and block it. Nobody has time for that these days, alright? Okay. So, we are going to go over first off what HIPAA is. There's a lot of information we're going to be going through because when it happens to be dealing with someone like RFK Jr., the details that you think are meaningless actually start to matter in ways you can't even imagine. So, we're going to start with the summary, and we're just going to start going straight through. So, this is a summary of key elements of the privacy rule, including who is covered, what information is protected, and how protected health information can be used and disclosed. Because it is an overview of the privacy rule, it does not address every detail of the provision. I just said, as I said, details are important. So there's going to be more deep diving. Right now, we're mainly just doing an introduction and an overview. So let's get to the introduction, shall we? One second. Also, trigger warning, allergies. You may hear weird sounds come out of me. I apologize in advance. I do not know how to use the edit button. The standards for privacy of individual identifiable health information privacy rule establishes, for the first time, a set of national standards for the protection of certain health information. The U.S. Department of Health and Human Services, HHS, issued the privacy rule to implement the requirement of the Health Insurance Portability and Accountability Act of 1996, also known as HIPAA. The privacy rules standards address the use and disclosure of individuals' health information, called protected health information, by organizations subject to the privacy rule, called covered entities, as well as standards for individual privacy rights to understand and control how their health information is used. Within HHS, the Office for Civil Rights, OCR, has responsibility for implementing and enforcing the privacy rule with respect to voluntary compliance activities and civil money penalties. So, I would hope it would be obvious why I feel like this is important information to go over, and exactly why I feel you need to know exactly what HIPAA protects and how to utilize and wield that protection if necessary. Considering the person that we have as head as HHS right now is completely insane. I'm not saying that to be derogatory in any way, but he's been insane for years. If you could time travel to 2008 and go into my office at the state and told me that that crazy guy was going to be the head of public health, I would have told you to put down the crack pipe. But here we are. So we are going to learn what can be protected, how it can be protected, if we need to lodge a complaint, and what that process all looks like. Because unfortunately, right now, we've always needed this, but right now, we really, really need to know this. Alright. A major goal of the privacy rule is to assure that individuals' health information is properly protected while allowing the flow of health information needed to provide and promote high quality health care and to protect public's health and well being. The rule strikes a balance that permits important uses of information while protecting the privacy of people who seek to care and healing. Given that the healthcare marketplace is diverse, the rule designed to be flexible and comprehensive to cover the variety of issues and disclosures that needed to be addressed. This is a summary of the key elements of the privacy rule and not a complete or comprehensive guide to compliance. Entities regulated by the rule are obligated to comply with all of its applicable requirements and should not rely on this summary as a source of legal information or advice. To make it easier for entities to review complete requirements of the rule, provisions of the rule referenced in this summary are cited in the endnotes. And we'll go over the privacy rule section to view the entire rule as we go throughout this series for other additional helpful information about how the rule applies. In the event of a conflict between this summary and the rule governs. Now I'm going to mention, yes, I am a whiz at PowerPoint. And I could have made this a lot powerful for you guys, but unfortunately these days you have to buy PowerPoint separately. And I'm a cheapskate who needs her teeth fixed first. And gums. So I'm going to apologize for that in advance. Let me go ahead and continue. Statutory and regulatory background. The Health Insurance Portability and Accountability Act of 1996, HIPAA Public Law 104-191, was enacted on August the 21st, 1996. So it hasn't always been around, guys. Like, the 80s it wasn't there. Yeah. Sections 261 through 264 of HIPAA require Secretary of HHS to publicize standards for the electronic exchange, privacy, and security of health information. Collectively, these are known as the Administrative Simplification Provisions. HIPAA required the Secretary to issue privacy regulations governing individually identifiable health information if Congress did not enact privacy legislation within 3 years of the passage of HIPAA. Because Congress did not enact privacy legislation, HHS developed a proposed rule and released it for the public comment on November the 3rd, 1999. The department received over 52,000 public comments. The final regulation, the privacy rule, was published in December the 28th, 2000. So again, hasn't been around that long. I say, well, I'm 40. In March 2002, the department proposed and released for public comment modifications to the privacy rule. The department received over 11,000 comments. The final modifications were published in final form on August 14, 2002. A text combining final regulation and modifications can be found, and again, we'll be deep diving that obviously later. I wanted to get through the overview first, and I can already see that's going to be more than one video. Right, so who is covered by the privacy rule? The privacy rule, as well as the administrative simplification rules, apply to health plans, healthcare clearinghouses, and any healthcare provider who transmits health information in electronic form in connection with transactions for which the Secretary of HHS has adopted standards under HIPAA, the covered entities. So a part of the reason of why we have HIPAA now, that's right, the onset and coming of the internet made people nervous, and considering what we've seen happen, thank God they thought to come up with HIPAA during the information age, because things, ooh, yeah, it wouldn't have been good, folks. It wouldn't have been good at all. All right, so health plans, we're going to start with that. Individual and group plans that provide or pay the cost of medical care are covered entities. Health plans include health, dental, vision, and prescription drug insurers, health maintenance organizations, HMOs, Medicare, Medicaid, Medicare Plus, Choice, and Medicare Supplement insurers, and long term care insurers excluding nursing home fixed indemnity policies. Health plans also include employer-sponsored group health plans, government and church-sponsored health plans, and multi-employer health plans. There are exceptions. A group health plan with less than 50 participants that is administered solely by the employer that established and maintains the plan is not a covered entity. Two types of government-funded programs are not health plans: those whose principal purpose is not providing or paying the cost of health care, such as the Food Stamps program, and those programs whose principal activity is directly providing health care, such as community health center or the making of grants to fund direct provision of health care. Certain types of insurance entities are also not health plans, including entities providing only workers' compensation, automobile insurance, and property and casualty insurance. If an insurance entity has separable lines of business, one which is a health plan, the HIPAA regulations apply to the entity with respect to the health plan line of the business. So HIPAA only covers health. I mean, that's pretty self-explanatory. I've never had to worry about it in regards to cars before. Healthcare providers. This is the one that we all need to pay extra special attention to. Every healthcare provider, regardless of size, who electronically transmits health information in connection with certain transactions is a covered entity. These transactions include claims, benefit eligibility inquiries, referral authorization requests, or other transactions for which HHS has established standards under the HIPAA transactions rule. Using electronic technology such as email does not mean a healthcare provider is a covered entity. The transmission must be in connection with a standard transaction. The privacy rule covers a health provider whether it electronically transmits these transactions directly or uses a billing service or third party to do so on its behalf. Healthcare providers include all providers of services, institutional providers such as hospitals, and providers of medical and health services, non-institutional providers such as physicians, dentists, and other practitioners, as defined by Medicare, and any other person or organization that furnishes bills or is paid for healthcare. So, that kind of makes it pretty straight, right to the point, right? Healthcare clearinghouses. Healthcare clearinghouses are entities that process non-standard information they receive from another entity into standard format, or data content, or vice versa. In most instances, healthcare clearinghouses will receive individually identifiable health information only when they are providing these processing services to a health plan or healthcare provider as a business associate. In such cases, only certain provisions of the privacy rule are applicable to the healthcare of clearinghouses uses and discloses protected health information. Healthcare clearinghouses include billing services, repricing companies, community health management information systems, and value-added networks and switches if these entities perform clearinghouse functions. So, even with that, you're still covered. Business associates. Business associates defined. In general, a business associate is a person or organization other than a member of a covered entity's workforce that performs certain functions or activities on behalf of or provides certain services to a covered entity that involve the use or disclosure of individual identifiable health information. Business associate functions or activities on the behalf of a covered entity includes claims processing, data analysis, utilization review, and billing. Business associate services to a covered entity are limited to legal, actuarial, accounting, consulting, data aggregation, management, administrative, accreditation, or financial services. However, persons or organizations are not considered business associates if their functions or services do not involve the use or disclosure of protected health information, and where any access to protected health information by such persons would be incidental, if at all. In other words, if their services has nothing to do with the transfer of your health information in some form electronically, then they're not covered. If they are involved with that kind of transfer information, then the HIPAA law does cover that type of situation. Business associate contract. When a covered entity used as a contractor or other non-workforce member to perform business associate services or activities, the rule requires that the covered entity include certain protections for information in a business associate arrangement. In certain circumstances, governmental entities may use alternative means to achieve the same protections. In the business associate contract, a covered entity must impose specified written safeguards on the individually identifiable health information used or disclosed by its business associates. Moreover, a covered entity may not contractually authorize its business associate to make any use or disclosure of protected health information that would violate the rule. They can't go selling your information. That's a big no-no. Covered entities that had an existing written contract or agreement with business associates prior to October the 15th, 2002, which was not renewed prior to April the 14th, 2003, were permitted to continue to operate under that contract until they renewed the contract or April the 14th, 2004, whichever was first. Of course, there's an additional guidelines there. We will be going in depth again. I just wanted to give you guys an overview. All right, what information is protected? That is the big one. The privacy rule protects all individually identifiable health information held or transmitted by a covered entity or its business associate in any form of media, whether electronic, paper, or oral. The privacy rule calls this information protected health information, or PHI. Individually identifiable health information is information including demographic data that relates to the individual's past, present, or future physical or mental health or condition, your diagnoses, the provision of health care to the individual, the past, present, or future payment for provision of health care to the individual. And that identifies the individual or for which there is a reasonable basis to believe it can be used to identify the individual. Individually Identifiable health information includes many common identifiers such as name, address, birth date, social security number. So you can see why, yeah, you want that locked up tighter than the Federal Reserve. The privacy rule excludes from protected health information employment records that a covered entity maintains in its capacity as an employer, and education and certain other records subject to or defined in the Family Educational Rights and Privacy Act 20 USC 1232G. De-identified health information. There are no restrictions on the use or disclosure of de-identified health information. De-identified health information neither identifies nor provides a reasonable basis to identify an individual. There are two ways to de-identify information: either a formal determination by a qualified statistician, or the removal of specified identifiers of the individual and of the individual's relatives, household members, and employers is required, and it's adequate only if covered entity has no actual knowledge that the remaining information could be used to identify the individual. So I think that's a good start to our introduction for the HIPAA series. Obviously, you can see that this is going to be a longer going series because we're going to be deep diving into these policies. I want every single one of you to know what is protected, how you can file a complaint if any of your if this rule is violated in any way. We're going to be going